The following is lecture number 2 in the Criminal Procedures course, Adjus 122. The topic is the Exclusionary Rule. All rights are reserved, and copy of this lecture or audio material may not be distributed without the express permission of Rick Ramos or Contra Costa College. First, we're going to talk about the cases leading to the Exclusionary Rule. As an introduction, you need to know that to study police procedures in their proper legal context, it's necessary at this point to introduce one of the most important rules of law that law enforcement officers have to obey, and that is the Exclusionary Rule. It's a procedural rule that officers must have on his or her mind every time they stop someone or conduct an investigation and are involved in the collection of evidence. It's also a procedural rule that every defense attorney knows well and will use to try to exclude evidence in a 1538 hearing in California from a criminal case. In most instances, an officer will have to go onto the stand and testify under oath as to the circumstances leading to a stop, arrest, or collection of evidence, and a judge or magistrate will make a decision regarding the admissibility of that evidence. If it's found that the officer violated the Fourth Amendment of the Constitution, then the magistrate will exclude the evidence no matter how relevant it is. The Exclusionary Rule is a prime example of a procedural law created by case law, created by a decision of the United States Supreme Court. It simply says that evidence seized illegally by the government, which is the police, is inadmissible in a court of law to prove guilt. The reason the police have to follow this rule is obvious. They're not supposed to violate the Constitution and the Fourth Amendment and seize evidence illegally, because it will not be used in court against the accused. It will result in the suppression of evidence. Without the evidence of the crime, the state can't make its case, so the suspect will go free. But before we go further, we want to talk about terminology for this lecture. The first term is articulate. This means to explain or to validate in writing or orally. When you stop someone, when you observe a crime, when you interview a witness, you have to explain that in writing or orally on the stand regarding criminal investigations. Probable cause means different things to different people, but in general it means that any person in the same situation would believe that the person you have in custody committed the crime. Now, we know that judges look at two things when they're determining probable cause in a hearing, in a preliminary hearing, and that is, number one, that a crime was committed, number two, that the person that's in custody probably did it. The third terminology, again, a repeat reasonable suspicion. A person is linked to a crime or possible criminal activity and it needs to be checked out. They may be asked to stop so that they can be questioned. Next, search, to look, touch, feel intentionally with the intent to find evidence to convict in a court of law or for the purposes of securing evidence or to protect the public. Accusatory process, from arrest through arraignment. Trial court, it decides guilt or innocence and the question of fact, did the person do it? Appellate court evaluates the trial court for error. Some of the cases that relate to the Exclusionary Rule include Weeks versus the United States in 1914. A man named Weeks was suspected by police of being involved in illegal lottery gambling, and on December 21st, 1911, in Kansas City, Missouri, local police went to his residence while Weeks was at work to search for evidence. After being told by a neighbor where the door key was hidden to that house, they searched his room and removed various papers and other personal property, which they turned over to the U.S. Marshal. Later that same day, the police returned to Weeks' residence, accompanied by the marshal, where they were admitted by another person. They completed a more extensive search and took away many of Weeks' personal effects, including letters and lottery tickets showing his illegal activity. Weeks was arrested at the express office where he worked at Union Station. He was charged in federal court, and he petitioned the court for return of all his effects, claiming they were illegally seized because the police didn't have a warrant. His petition was denied, and he was convicted, fined, and imprisoned. Weeks appealed to the U.S. Supreme Court, and his case was argued before it on December 1913. 2 years after his arrest and conviction, the court announced its decision on February 24, 1914. Chief Justice Day wrote the opinion of the court and stated, if letters and private documents can thus be seized and held and used in evidence against a citizen accused of an offense, the protection of the Fourth Amendment, declaring his right to be secure against such searches and seizures, is of no value. So far as those that thus placed are concerned, might as well be stricken from the Constitution. Therefore, reach a conclusion that the letters in questions were taken from the house of the accused by an official of the United States acting under the color of his office in direct violation of the constitutional rights of the defendant. And so what they basically did was they said, if you violate the Fourth Amendment, then we are going to exclude the evidence based upon that violation, no matter how legal and relevant it is. Although the Supreme Court did not mention the phrase exclusionary rule, its decision created the rule, and the phrase was created later. 20 states adopted the so-called Weeks Doctrine into their own body of procedural law. Iowa had enacted their own version of an exclusionary rule even before Weeks. However, 27 states decided not to follow Weeks, and for a majority of the local police and sheriffs, it was business as usual, making whatever legal searches and seizures they wanted for the next 47 years. In fact, the federal court allowed the admission of illegally seized evidence, even if it was seized by local police and not federal officers. Consequently, federal agents suspected contraband located in the house and wanted to make a search. All they had to do was just have local police just simply come in and get the evidence, pick it up, hand it to the federal police, and they would submit it simply because the state police were not held to the same scrutiny that they were. The practice became known as the silver platter doctrine because the federal agents would be handed good evidence on a silver platter by the police, and then they would submit it to the federal courts for approval. But the mother of all cases regarding the exclusionary rule was Mapp versus Ohio. Now, this is an interesting case. It starts with Don King, the infamous boxing promoter. You know, the guy with the weird hair, African-American boxing promoter that handled Mike Tyson. Don King was from Cleveland, Ohio, and he had a nightclub with a friend of his, and the mafia came by and tried to shake him down for protection money. They refused to pay it, and the mafia, one of the chieftains, killed Don King's partner. It was actually the son of the mafia boss locally in Cleveland. So Don King got a gun and went and killed his son. And he ended up going to prison for manslaughter as a result of that. That was the conviction he had as a felon. In the meantime, the mafia sent a bomber to Don King's house, and it blew the front of the house off, but it didn't kill him. And he basically ratted him out. And the police ended up at the house of Dorley Mapp. Now, Dorley Mapp was the alleged girlfriend of the bomber. The police show up at Dorley Mapp's home. They show her a piece of paper. There's really nothing, telling her it's a search warrant. They make her stay downstairs, and they go up and they do a sketch of the home. And they go into a closet. They find a drawing box because she's an artist. They find a pencil sketch of a naked person. And the sketch is determined to be pornography, and Mapp gets 7 years in prison. Now, as a result of that, the Supreme Court basically said that the Mapp decision stands as a watershed in the history of criminal due process. It established one of the most controversial procedures of our time, the exclusionary rule, as a mandatory procedure in all states. So it made it mandatory that all states would have to observe the Fourth Amendment, and that no longer could they seize evidence illegally and expect it to be allowed in a criminal court. There are some exceptions to the rule, and I want to talk about that for a minute. So first of all, let's go back over what is the exclusionary rule. It's a punishment for the police for violating defendants' rights. No matter how relevant or reliable evidence is, it can be excluded. So an officer stops a car for no reason. During his interview with the driver, the officer illegally takes the driver's keys and opens the trunk of the car. They find a dead body and a knife used to stab the victim, and it has bloody fingerprints on it. They run the fingerprints. It comes back to the defendant driving the car. Guess what? The whole thing's going to get thrown out because it was an illegal stop in the first place. There's no reasonable suspicion for the stop. There's no reasonable suspicion for the trunk search. And we'll talk later about how you can do a trunk search. going to talk about some of the exceptions to the exclusionary rule. One is the inevitable discovery exception, and this goes back to about 1968. There's a case where a young girl is kidnapped, and the suspect, Robert Williams, is seen leaving a place with a large bundle wrapped in a blanket. And someone saw him throw this bundle, like a duffel bag or what have you, into a car, and that they could see two legs that were shiny and white. So the suspect goes out into the, this is Williams, goes out into the desert, and this is in Iowa, and he buries the body. And so now what's going on is they're following up leads. They know that most likely it's Williams that did this. They get a search party, and the search party stretches out like over about 50 yards, and they're starting to comb the back areas in the city to try to find the body. And at the same time, they make an arrest on the suspect, and they have 200 volunteers from the local community who come out of concern for the child, and they divide into teams. They start the search, and they're looking all over the roads, abandoned farm buildings, ditches, culverts, any other place where the body might be buried or hidden. And the suspect turns himself in. Two detectives drive to Davenport, Iowa. They take him into custody, and they're going to drive back to Des Moines. However, before they left the police station, they researched the file on Williams and learned that he was of low intelligence, and that he was a religious fanatic of fundamental beliefs. So, on the return trip, they do what's called the Christian burial speech. This is a famous historical event in jurisprudence. And they basically say, geez, have you ever seen what coyotes do to, human remains? And, this poor girl deserves a Christian burial. Don't you think so? And they're talking to each other in the front of the car. Well, Williams is in the back of the car. They have not Mirandized him. He starts to feel guilty, and he tells them where the body is. He just blurts this out. He's convicted, and the statements are later excluded because of violation of Fifth and Sixth Amendment. Now, the court decides the police would have found the body without the statement later on after it's thrown out, and they overturn the rule and basically say that it was inevitable that the body would have been found because the 200 volunteers were about to go right into the area where they found the body and would have found it. And so this becomes a new rule. Let me give you an example of something that I know happened in my career. We had a shooting, and we're looking for a gun, and the suspect, we weren't sure who the suspect was, and an arrest was made by one of our officers. The probable cause was shaky, and they ended up interviewing him, and they got some information from him, but they said because the probable cause on the arrest was shaky that everything else had to be thrown out, and he basically gave us information where a gun was. At the same time, an informant was telling us that the guy had a gun. It was similar in fashion to the one we're looking for, 9mm, and that it could be at his girlfriend's house. His girlfriend had talked about having hidden his gun. So we write a search warrant to go find the gun. There's one detective doing that. Well, in the meantime, this patrol officer is treading all over this guy's rights, and he finds the gun. When we go into court, the gun is allowed in because they say inevitably the officer who was doing it legally would have found the gun with the search warrant. And that's how that case went down. Many times, this other term I want to explain to you is called the fruits of the poisonous tree. And what that means is that if you have a bad search, and that bad search leads to other bad searches or other evidence that might be admissible, it has to be thrown out. Because think about it. If you have a poisonous tree, first of all, you have fruit that comes from the poisonous tree. It's going to be poisonous. If you were to replant it, it's going to grow another poisonous tree. So the thought was that they wouldn't let that happen. But I want to get back to inevitable discovery. It is one of the exceptions to the exclusionary rule. So let's evaluate this again. Williams is arrested. He's transported in a police vehicle. The police make him feel guilty, and he tells them where the body is. The body found using info that they got from Williams, info on the body excluded from trial, and the finding of the body is excluded, and that the argument that gets it back in is that the search team would have found the body anyway, and the term inevitable means that something would have happened anyway, no matter what. Now let's take this to the present, and let's look at a current case, and this is a case called U.S. versus Holmes. It just came out in 2007, and in this case, we had some officers who make a stop on an individual that they believe is dealing dope. And in this case, we have some issues that we have to deal with. The first is, while pat searching Holmes, did officers have grounds to remove car keys in his pocket? Now, we know under Terry versus Ohio that we're allowed to remove any object that's hard that appears to be a weapon, but the officers never articulate in their report or on the stand as to whether or not the item that they find they believe to be some sort of weapon of some sorts. The second issue is, if they don't have the grounds to search or to remove the keys, if not, was a handgun discovered as a indirect result of the search admissible under inevitable discovery or attenuation rules? So let's go back and let's talk about this case. It's about 3:30 in the morning, and two officers from the Metropolitan Police Department on patrol in the District of Columbia see a man and a woman standing together in an alley frequented by local drug dealers and prostitutes. When the pair saw the patrol car, they ran off in different directions. The man, later identified as Holmes, was quickly apprehended. Before doing anything else, one of the officers pat searches him and in the process felt a set of keys inside one of his pockets. He also saw some cigarette rolling papers protruding from another pocket. After removing these items, the officer asked him why he had run. Holmes said that because he had been soliciting sex from the woman. Holmes had told the officers that he had lived in Maryland and that he was taking the train into D.C., but when they pointed out that the trains didn't run at this hour, he changed his story and said that a friend had dropped him off. So they asked him why he was carrying car keys, and at that point he admitted he had driven in, they had parked down the street. One of the officers then activated the remote control device on Holmes's key ring, which caused the lights to flash on an Acura parked down the street. Suspecting that there were drugs inside the car, the officer asked Holmes if he would consent to a search of the car. At that time, they also happened to mention that he was arrestable for possession of rolling papers. Must be that paraphernalia is illegal in that jurisdiction. Holmes consented to the search and signed a consent form. Although the officers did not find any drugs in the vehicle, they did find a Ruger handgun under the driver's seat. As a result, Holmes was convicted of possession of a handgun by a felon. On appeal, the government conceded that the officer who pat searched Holmes had exceeded the permissible scope of the search when he removed the car keys, which obviously did not pose a threat to anyone and were not evidence of a crime, at least at that point. Because the keys had been seized illegally, Holmes argued that the handgun should have been suppressed. Now let's talk about inevitable discovery. Under the inevitable discovery rule, evidence that was obtained illegally will not be suppressed if prosecutors can show that it would have been obtained inevitably by legal, lawful means. Prosecutors need not, however, show that evidence would have been found unquestionably or certainly. Instead, they must prove that there is a reasonable, strong probability that would have been discovered in the normal course of the lawful conducted investigation. Now, in this case, they cite the Nix case, Nix versus Williams again, that we looked at earlier. And in that case, the United States Supreme Court ruled that because the members of a search party were only a short distance from the body of the murder victim they were seeking, the body was admissible even though it was actually discovered by officers as a result of their questioning and the violation of the defendant's Sixth Amendment rights. So citing Nix, the prosecutors suggest that the officers, having lawfully felt the car keys in Holmes' pocket, might have asked him where his car was parked and that Holmes might have answered truthfully. The court responded, all of this is nothing more than probability, and the evidence of inevitable discovery, this fails. It doesn't work. So, Here's what happens. The prosecution argues that the consent search constitutes such an unexpected act as would be expected in this case, and that there are facts, many cases in which the court have ruled that suspects' post-search consent constitute an independent intervening act. Because what it says is that you can allow something in if something unexpected happened between the illegal search and the discovery of the evidence, or that an unexpected event played a sufficiently important role in the discovery of the evidence so as to break the chain of causation. First, the seizure of Holmes' keys played a direct role in the discovery of the gun. Specifically, the keys resulted in Holmes' admission that he had driven into town. More importantly, it led to the officers to his car. And also somewhat significant that the seizure of the keys enabled the officers to unlock the car just before they sought Holmes' consent to search it. Second, even though the officer did not engage in blatant coercion, the court ruled that they had intentionally created a coercive environment in which to seek Holmes' consent. The bottom line is that the court, in this case, said that the gun should have been suppressed and overruled on the appeal. Public safety exception, New York versus Quarles, 1984. So what happens is the police arrest Quarles in an A&P market, which is like a 7-Eleven, after he's identified as a rape suspect. Upon arrest, he's searched and he has an empty shoulder holster on him. Officers ask him where the gun is, and he directs the officers to a carton with the gun in it. Officers Mirandize Quarles, stating he will speak to the officer, and he states he'll speak to the officer. Now, the original gun charge was overturned because of a procedural error by the officer. In other words, he should have Mirandized him first because he arrested him. But the officer claimed that the public safety demanded he ask where the gun was before reading Miranda to the suspect, and the public safety exception was established. They allowed this in because you have children and other people in that market who might have found that gun, and it could have been extremely dangerous. The good faith exception. When officers in good faith believe they are following the law, they will be given some consideration for the purposes of evidence collection. Talk about the Willie Shepard case. In the Shepard case, basically Shepard kills a woman, he rapes her, and he sets her on fire. It's a Sunday and the police are going to write a search warrant, and all they can find is drug search warrant forms. Because it's Sunday, they're out of the regular forms. So they strike out all the information on drugs and they take it to a judge. They explain to that judge why the forms are the way they are with all these marks on them. The judge makes additional changes and approves the warrant. Now, they are able to find a gas can, some wire she was tied up, a rope she was strangled with, and all this evidence is used to convict him in court. But the trial court then makes a decision that because they used a wrong form, that all the evidence should be excluded. Now, the Supreme Court looked at this case and overruled a ruling stating that the police could not have done more than try to legally write a warrant. They went to a judge, they asked for advice, they're just the police. And that if a judge knew what they wanted, they were acting in good faith, and therefore the evidence that was found legally with the warrant will be kept in court, be allowed in. Searches that you can use incident to arrest. Chamel search. Incident to arrest, you could search a suspect anywhere within their arm's span. You can look in drawers, you can look in cabinets, you can look in their jacket, you can look in containers, you can look inside the interior of a car where a arrestee was at or leaning against, as long as it's within reach, if they could have thrown evidence in there. So if I'm standing in front of a desk, I could look through all the desk, or the officer can look through the desk when they're making a search. The next case I'll talk about is the Belton search, the Belton case. Any container in the suspect's control, including a jacket that might not be on the suspect but might be in his car. The pockets in the jackets are all containers. A purse or other container in the car, and it might not even be the purse that belongs to the suspect. It could be a purse that belongs to his girlfriend, but because it's within arm's span, it's under his control, and therefore you can search it. And if you find articles in it that are related to the girlfriend, she can go to jail too. Other vehicle searches include the Carroll search. So here's an example of how the Carroll search works. You have probable cause to arrest the suspects in the car and you're looking for specific evidence. Let's say that you're responding to a robbery in progress. It's of a bank. The suspects were wearing ski masks. They were using duct tape. They had shotguns. They took money bags marked Wells Fargo. When you pulled them over, the suspects have none of this in the car, but they match the description of the vehicle perfectly. Matter of fact, in the back of the car, maybe there is some shotgun shells. So you know you got the suspects. They're in the area contemporaneous to the crime, and you don't have any of the evidence you're looking for. So what you do is it's logical to go in the trunk to look for the evidence. So you go into the trunk and voila, you find the evidence. So what Carol does is it says that if you look in the front of the vehicle and you're looking for specific evidence, it's not there, but you got probable cause to arrest, and it's logical it's in the trunk, that you can go in the trunk. The reason you can go in the trunk on a car is a car has a lower expectation of privacy than a home. And also a car is movable, it's on wheels, it can go anywhere. So this is exigent. Another car could ram into it in the middle of the intersection, has to go somewhere. You know, you have to move it. Now, you could impound it, you could take it in. We're going to talk about that right now. If you decide to impound a car, you have somebody who is driving without a driver's license under 14601 of the Vehicle Code in California, you could tow the vehicle. You can impound it for 30 days. If you're going to tow a car, you have a responsibility to open the trunk to inventory any valuables that might be there. Usually you're going to have some sort of a standard form. While you're inventorying that trunk, if you find any contraband or stolen property or other evidence, it's admissible in court. Other searches. Search warrants. Affidavit for a search warrant is written explaining probable cause, and this is submitted to a magistrate for review. If the magistrate believes that the evidence you're looking for is at the address you have listed on the search warrant, they'll sign the search warrant. The search warrant has to be served within 10 days, and there must be a return of search warrant or a list of the evidence that is confiscated returned to the court within that 10 days, otherwise it's going to be thrown out. Other searches also include probation and parole search clauses. As a condition of being released early or not going to jail, suspects allow search of their homes and autos as a condition of release. They include search of any container in the control of the suspect, including passengers' bags. So if you're in a car with a parolee, your property might get searched. You better be careful. Make sure that you review the key terms in your textbook. I'm going to review some of those with you right now. Christian burial speech, the exclusionary rule, fruit of the poisonous tree, good faith exception, inevitable discovery exception, the MAP decision, public safety exception, silver platter doctrine, suppression of evidence, and the Weeks doctrine. So you need to look those up. This is the conclusion of Criminal Procedures Lecture 2 on the Exclusionary Rule.